Good afternoon and welcome to today's webinar, Hotline Property Management Topics with Attorney Rick Mack. I'm Beth Hawley with the Arizona Association of Realtors. Rick Mack has been practicing law since 1990. He is a State Bar of Arizona certified real estate specialist and is the lead attorney for the Arizona Association of Realtors Hotline program. Today's presentation will be about 45 minutes, followed by 15 minutes of Q&A, give or take 15 or 20 minutes. If you have any questions during the webinar, please write them in the question box as seen on your screen, and we will be sure to address them. As always, today's webinar is being recorded and will be available on our website at aaronline.com. So what's percolating on the hotline these days, Rick?
You know, we're super busy. I'll give you some statistics for 2016. We just finished it up. We had 5,383 calls in 2016. That is 448 a month and about almost 22 per day. So we're super busy. One of the common themes we're seeing are property management questions and landlord-tenant questions, hence our webinar today. Just if you're a numbers geek like I am, the landlord-tenant questions last year were 554. The property management questions were 161 for a total of 715. That's roughly 13% of all the calls came in on either landlord-tenant or property management questions. That is the single biggest topic we have. So there's a need out there. We're trying to reach out and make sure we address some of your questions and kind of let you know what's going on. So that's what's hot with the hotline. The other thing, as we go, if you have questions that are topical, because we're going to talk about some general concepts, and then we're going to dive down into some of the documents that are at least the hot issues I'm seeing, some of the flash spots, if you will. If you have questions about any of the documents as we go, type them in. We'll try to figure it out and answer them timely instead of doing it all at the end. I think it'll make more sense if we can have a discussion as we go. So with that being said, let me just dive right in. First of all, the distinction between a property manager and a leasing agent. I assume most of you are property managers and also act as leasing agents in that capacity as well. But there's a difference. You don't want to be an accidental property manager, to quote Sue Fluke, the queen of Arizona property management as far as I'm concerned. Sue, you out there? I don't know if she's hearing us or not. So as a property manager, what do? First of all, let's back up with the basics. You have to have a signed property management agreement. You have to define what you're going to do, and it has to have a definite term on it. So as a property manager, if you're going to do the functions of a property manager, you've got to have a signed document. What else do? You probably market, you negotiate the lease, you sign the lease maybe on behalf of the landlord if they allow you to. You collect rent. You account for the rent, you hold the security deposit, you arrange for the repairs, you pay the expenses, and then at the very end you get to deal with the potential deadbeat tenants that may or may not pay. So your laundry list of things you have to do as a property manager is significant. There's a lot of things you have to do. And contrast that with a leasing agent. What do? They market the property, they negotiate and draft a lease, and then they're done. So it's a different animal to be a property manager versus a leasing agent. And again, if you're going to do the leasing and only be a leasing agent, that is fine. That's acceptable by statute. But make sure you don't do anything more. Once you start arranging repairs, collecting rents, dealing with those types of things, you're going to be a property manager by statute, and you're going to have to deal with all the issues that come with that, and primarily a property management agreement. I've defended people at the DRE where they were, in essence, a de facto property manager, and they didn't have an agreement in place. That's a violation. 322173 specifically says you have to have a property management agreement in place. So there's a difference between a property manager and a leasing agent. And in my mind, it's an important difference. So make sure when you're dealing with those issues that you do just that. A couple more things before we dive into the documents. Handling of the money. Believe it or not, there are specific statutes on point to handle the money. So you're now for sure a property manager. You're not a leasing agent. You're going to handle some money. What do you have to do? First and foremost, the trust account money, it's not yours. Don't spend it. Don't go to Hawaii. Don't go to Saks. Don't spend those funds somewhere else. And you've all seen the horror stories where property management brokers took the funds, treated them as their own, and there are some consent decrees and some decisions down at DRE where literally these people were taking the funds and going on a Caribbean vacation. That's not proper. So remember, basic rule 1, trust account is not yours. Don't spend it. That's the Department of Real Estate's biggest focal point and has been for years in terms of what they're going to investigate. Related to that, and again, that focal point is based primarily on that dozen or so bad actors who took money, and sometimes 7 figures, took a lot of money from unknowing owners. So remember, trust account funds are not yours. Don't spend it. I don't care if it's a really good necessary expense like groceries or college tuition. Don't spend it, not your money. The second piece, if you are a property manager, you're more than likely going to have a trust account. Very specific rules and regulations. You have to reconcile that trust account. No ifs, ands, or buts. You can't treat it like your checking account and figure, well, there's still money there, it's going to be fine. No. If you get audited by the department, they're going to look for a monthly reconciliation of your trust account. Hopefully all of you are doing this already. If not, hire a bookkeeper or CPA immediately and get that taken care of. So you need to reconcile your trust account every month. Those are the 2 big issues with trust accounts and trust accounting. It's not your money, and reconcile on a regular basis. A couple more points before I move on. ARS 322174 addresses what you're supposed to do. If you're going to deposit money, if you're going to handle money and pay bills, you must have a trust account. Second piece, who may sign on this trust account? Designated broker may sign, or they may designate a licensee to sign. Either one is acceptable under the statutes. DB or a licensee may sign on a trust account. Third piece, monies must be deposited within 3 days of receipt. So once you get it, you can't put it in your trunk and let that check sit there for a week. It has to go in within 3 days by statute. And DRE will look at that too. They will look at date of check versus date of deposit. And if you don't get it there quickly enough, they're going to call you out. That's going to be a violation. They're going to ask you for a consent decree, and you have to deal with all that drama. So you have 3 days under 322174D to get the money deposited. And then finally, the rental agreement must specify where the money is going to go. So if you're going to hold the security deposit as the property manager, that's all well and good, but you have to notify the tenant. The documents have to show who's holding the money and how much money is there. So those are the kind of the big ticket items for money and accounting. And again, it's all common sense, but there are some pretty technical rules in terms of compliance, so make sure you get that taken care of. One more piece before we dive into the forms, record keeping. 322175 requires certain aspects in terms of keeping records. First of all, a rental agreement must be maintained for 1 year after it expires. A little different than the purchase contract side because that's 5. 1 year after lease expires, you must maintain a copy of the rental agreement. Second piece, you must maintain all, the statute says all, financial records for 3 years. 3 years to maintain financial records. Hopefully you can do that on your computer. Hopefully you have it in electronic format, because if the department comes, it's going to be a whole lot easier for you to do things electronically than to shuffle through paper. So maintain financial records for 3 years. And then finally, under the record keeping section statute, again 322175, if you're going to sign as a property manager on behalf of the owner, you have to be a licensee, either the licensee or the designated broker. And we'll talk about that in a minute. As a property manager signing for the owner, allowed by statute, a little bit risky. Long distance owners, I get it. My preference in my world is that owners sign documents. I know that's not consistent with a lot of your practices, but if I had my druthers, if we're talking about risk reduction here, you signing on behalf of a landlord gives room for disputes, because landlords can say, I never would have approved that tenant. What do you mean? He's a convicted felon. What do you mean she flaked on her rent the last 3 times? Why would you ever sign that lease with them? Or why would you ever lease the property at the rates you did? So there's so many things that could go wrong if you're signing for an owner. Most of you that are doing it have been doing it for a long time. You have parameters. You have, checkpoints in terms of what you're going to allow, what you're not going to allow. You have price brackets in terms of what price you'll take versus not. But again, if at all possible, my preference from a risk reduction point of view is to have the owner sign the lease documents. So that's sort of my basic introduction before I dive into the documents. Any questions on any of that? Nothing?
We do have a couple of questions. One, is a landlord responsible for the repair of appliances on garage door openers if the lease states that tenant is responsible for upkeep and maintenance?
Good question. And there's a couple ways to look at it. Because you have a garage door opener, I assume it's got to be a single-family residence. The lease may foist the responsibility for maintenance onto the tenant if it's a single-family residence. So if it's the contractual responsibility of the tenant in the lease, then yeah, the tenant needs to fix the garage door opener. It's all a matter of what you negotiate and how it goes from there, and what the documents say. Anything else?
Another one, an unlicensed person in the employee of a brokerage may also be a co-signer on the trust account. Is that correct?
If they are an employee, let me look at that. It's 3221.75 and 74. Yeah, there's a distinction there. If you're going to sign for the owner the rental agreement, then that person has to be a licensee. You can be a signer on the trust account as an employee and not a licensee. So I hope that makes sense. All right.
Other questions?
Moving on. Again, I want to dive into the forms, and we've got some good ones. It's funny because Sue Fluke and her team redid these things, and what seems like it was just a little bit ago, it's 5 years ago. The forms are from 2012. The property management landlord-tenant forms, in my mind, are some of the best ones we have. Before I get there, let me do one more thing. Whether you're a property manager or a leasing agent, if you are collecting money for a credit check, do the credit check. I've defended a couple people in civil litigation and with the DRE where they represent or they collect the money, 30, 35 bucks, whatever, for a credit check, and then they don't run it. That's a problem because oftentimes credit checks are critical. If somebody's got a 412 FICO score, you might not want them as your tenant. So if you're collecting the money, the consumer, your client, the landlord, is going to assume that you're actually doing that. And when you don't do it, and then that tenant later turns out to be a problem, you have some liability. So again, collecting money for a credit check, make sure you run the credit check. Before I dive into the forms, you got another question?
We have a question about setting up a trust account. What are the parameters for that? If it needs to be in the accounting system as a trust account.
Couple things there, and we can dive way down into this offline. If you want to call me, I can help you. But the short answer is this. With the bank, wherever you go to, especially the big national banks, Wells, Bank of America, Chase, you need to specifically identify the account as a trust account. So we'll say XYZ Realty Trust Account. That's perfect. The other thing, it needs to be separate and apart from your operating account. You You can't commingle your trust funds with your operating funds, so you need a separate account. And you should also reconcile the trust account separately. I've had questions, do I have to have a separate trust account for each specific property? No. You can have one trust account, but you do have to have a separate folder, if you will, a separate accounting for each property within your QuickBooks or whatever property management program you might be using. So those are the two parameters. Talk with a bookkeeper, talk with your CPA, but you do need to have a trust account designated as such with the bank. I see the screen lighting up. Before we dive in, what else we got?
But just a part two on that question. So if it's under the broker name, but it's completely separate, that's okay.
Yes, separate account, separate trust account, separate and apart from the operating account, still under the broker name, yes.
Okay, great. Like federal and state law, is there anything in the contract that could trump the Tenant-Landlord Act?
Wow, that's a good question. No, the Landlord-Tenant Act is the law of the land. You cannot document around it. For instance, you cannot agree that we're going to violate the Fair Housing Act. You cannot agree that I'm going to collect 6 months rent for a security deposit. So no, the Landlord-Tenant Act, and by the way, it's very tenant protective. The documents at issue cannot curb the requirements of the Landlord-Tenant Act.
So on
One more? They keep coming. All right, what else you got?
So on the credit report
Yes.
aspect of what you were talking about, are we required or allowed to then give the results to the tenant?
Tenant or the landlord, I guess the
I'm
question is. That's a tough one, because typically if you're eligible, if you sign up and get the credit reporting information, you have limits on what you can do with that information. It's typically private to you, the user. So before you start automatically sharing that data with your landlords, do one of two things. Either get the tenant's consent, or make sure that your user agreement with the credit reporting agency allows you to share that information on a very limited basis with the intended user, which in your case would be the landlord, the person who's actually going to agree this tenant's going to come into my house. I'm going to move on, I think, unless I see a bunch more, but I'll move on for now, and we can, if there's more we need to back up, we'll take care of those issues. The property management agreement itself, again, it's a 2012 form. It's a good form. I want to run through what I see are the hot spots, kind of what we're getting as issues on the hotline, and then if you have questions specifically about some provision form, let's talk about those too. First of all, look at line 3. You're going to lease, operate, and manage the property. So your duties are pretty broad, and landlords are going to look to you as effectively their boots on the ground to take care of the property. Still on page 1, line 11, term. I've said it before earlier, and I'll say it again now. You have to have a term on the property management agreement. There has to be a begin date and an end date. If you don't have those dates, you're violating the statutes, and you're subject to being cited by the Department of Real Estate. So that's one of the common calls we get. Why do I have to have a term? I'm going to do this forever. Why do I have to have an end date? You have to have an end date, non-negotiable. You got to get that piece taken care of. The other call we get commonly is cancellation. Can I cancel? What happens if I cancel? And can the landlord cancel? Can they fire me? The document addresses that as well. Effectively, either party can cancel with 30 days notice. If I'm a property manager, I'm going to give at least 30-day notice so the landlord can find somebody else to come take over. But if you want to cancel, you can give 30 days notice. The flip side, can the landlord cancel? The answer is yes, and you can negotiate a fee. If you look at the line 20, there's a cancellation fee of blank. If you want to plug in $2,000 or $200 or whatever number you want, If the landlord agrees to that, that's perfectly acceptable. So cancellation, either side can cancel. There are some consequences that flow from that, so make sure you deal with that. One more piece, and this is probably the most common question we get on the hotline. If I terminate or if I'm fired, what happens to the security deposits? I got a tenant saying to me, I want that money back, it's mine. I don't trust that landlord, he or she is flaky and crooked, and once you give to them, I'm never going to get my money back. You got a landlord saying, ha, give it to me, it's mine, you may no longer hold the property, or no longer hold the funds. Short answer is this, it's really pretty simple if you think about it. Even if you're torn, even if you fired the landlord because you think he's kind of crooked, the statutes and the common law out there talk about this. Remember, you owe the fiduciary duty to the landlord. They're your client. Part of the fiduciary duty is obedience. Within reason, as long as it's not illegal or immoral or contrary to public policy, you have to do what they tell you to do. If the owner says to you, I want that security deposit, issue me the check, you have to do it. You have to give them the check. We'll talk about the notice you have to give to the tenant here later, because you can't just write the check and run. You got to tell the tenant, and there's a form that we'll talk about that gives you the ability. You've got to give the tenant notice, hey, I no longer hold the money, the landlord does, but here's what you need to do going forward. So yes, follow the landlord's directions even if you don't like them, and however, notify the tenant of what you've just done. Next hot spot, marketing. I'm on page 2, and we just had a big Q&A on AAR Online with this, and there's a hotline letter published as well. Lockbox on a rental. What do you do with that? There are all sorts of issues that could arise to that. Specifically, I'm on line 41 through 44. We've got some interference going. I'll let you take care of that. All right, back on. The lockbox on a tenancy, on a residential tenancy, what's going to happen there? There's some conflicting dynamics that are going to get you in trouble potentially. I would recommend no. Is it legal? Sure. Is it advisable? No. And let me tell you why. Remember, before a landlord can access the property, there has to be 48 hours notice, and it has to be on reasonable terms. So 2 in the morning, 48 hours, no, not going to fly. 6 in the morning, probably not going to fly. You got to find a time that's reasonable, typically during business hours, maybe early evening with the tenant's consent. But you can't just show up whenever you want to and say, hey, I gave you 48 hours, here I come, I don't trust you, I think you're brewing crack cocaine or what is it? Meth. Meth is what you see, what a drug expert I am. Meth is what they brew in the sink. I think you're brewing meth, I want to come check it out. No, you can't do that. You have to give notice. If there's a lockbox there because the owner wants to sell it, what's going to happen? All of your colleagues who also have clients that might want to buy are going to see the lockbox, they're going to figure they have access, and then they're going to be entering the property in violation of the statute. Because again, remember, you need the 48 hours notice. So lockbox on a rental, super, super high risk, because inevitably if someone accesses it, and if you have a tenant who's got some flexible ethics, they're going to say, you stole my $50,000 Mickey Mantle card, and where is it? And guess what? Because you gave them access by way of this lockbox, there's at least a vehicle, a platform they can use to try to come get you for their loss. So again, the document says broker may install a lockbox containing a key for marketing purposes. Be careful. Be careful. I highly recommend against it, but again, if you have to do it, make sure you give the tenant notice. Make sure they acknowledge when you're coming and how you're going to come. One more piece on this form that I think is important is the accounting and the reports. We already talked about that. If you are going to do a property management agreement, you have to account to your owners. I recommend you do it monthly. You have slots where you can do it monthly, quarterly, annually, whatever. I propose monthly, and I also propose a specified time in the month. The 5th, the 10th, 15th, I don't care, but pick a date and use it. Hit the date every time. Set expectations and meet them. If you make it the 2nd or the 3rd every month, if a weekend falls in there and you happen to have the audacity of going on vacation, you're going to have some issues. So give yourself enough time. Make it the 5th or the 7th or something so it's timely, but you have a little bit of margin just in case you might want to have a real life. And again, you can report whenever you want. I would do it monthly because oftentimes there's communication that occurs by way of the accounting that the landlord may want to see. Got a question?
Is a CVS code pin okay for a lockbox?
CVS code pin, again, as long as you have tenant permission, sure. My bigger concern is not how you get in or the means you use to get in, it's just the fact of getting in. So yeah, the CVS pin, I think that's so you can track who's been there. But again, you're setting yourself up for risk. Just be super careful of that one. And again, I'm talking in the ivory tower. I know it's inconsistent with your practice. I'm just trying to tell you what to avoid. Any other questions on that before I move on?
No questions,
Good.
but I did want to make a comment that we are experiencing screen difficulties, and I apologize. The PowerPoint that you may or may not be missing is not essential to the conversation, though, so please hang with us. And we are ready to move on.
Technical difficulties. A couple more things, I'll move on to a different form. Property management agreement, compensation, where none of us are doing this for free. There are multiple fees you can and should collect if you're doing property management. Number one, the management fee, that's the monthly grind. You're collecting rent, you're paying bills, you're doing all that stuff. That's specified. The leasing commission, a lot of people don't collect a leasing commission. In my mind, you're doing the work, you're procuring a tenant, you're entitled to that leasing commission. Make sure you address that. And then sales. If there is an ultimate sale of the property during the term of the lease, then the document says you're due a commission. Actually, a sale to one of the tenants, obviously. So those are the three pieces where you can and should get paid. Some people sometimes ignore, figure they're going to make their money on the management, don't charge a leasing fee. If that's your business choice and your business model, that's all well and good, but the form specifically allows for a leasing commission. The industry typically contemplates you collecting a leasing commission. Don't be shy. Again, none of us are doing this for free. And I think that's all I have with respect to the property management agreement. It's a good form. It's the AAR form. It ought to be in your files. You should use it. If you don't use the AAR property management form, make sure you use a form. You have to have a written document addressing what you're going to do. Begin date, end date, terms, duties, compensation. You have to have all that stuff in writing per commissioner's rule and per statute. Again, I recommend you use the AAR form because that's a good one and it's easy, especially if you have a Hotline question. I can look right to it and know exactly what you're talking about. If you don't want to, if you have some pushback, that's fine, but make sure your form complies with the DRE rules and regs so you don't set yourself up for, one of those great little write-ups in the bulletin about what you did wrong. More questions? Should I move on?
One question. So if you have a tenant-occupied property and the tenant does not grant permission for you to go in, is there a fine? $5,000 property management company, is that correct?
I'm not sure I'm following the question, but the short answer is if the tenant does not give you permission and does not acknowledge your request to enter, don't enter. That's a problem. If you do enter, there is potential civil damage available from the civil claim damage available from the tenant against you as the property manager and potentially the owner. So I simply wouldn't let them in. And the $5,000 penalty I've never heard of. If that's in the Landlord-Tenant Act, maybe somebody can help me out, but I don't think there's a $5,000 penalty for wrongfully allowing someone access. It's a prohibition. You cannot do it, But my memory is, as I sit here right now without the statutes in front of me, is there's not a $5,000 sort of penalty for that sort of activity. Any other questions? You know, I've got one that actually just came across. Why would we want to terminate an owner? Why do we want to terminate our property management agreement? There are some things that are so offensive that you just don't want to do business with them. If someone's telling you, for instance, I'm not going to rent to a specified protected class, I don't like Irish lawyers, or I don't like Catholics, or I don't like Muslims, or I don't like whatever, that is a position that's specifically prohibited by state and federal law. That gives you, as a property manager, the absolute right to say, forget it, I'm not doing business with you, I'm out. So there are certain, and if they want a nickel dime tenants, if they don't want to fix things, if it's 115 in Phoenix and they won't fix the air conditioner in spite of your 17th request, you know, there's some people that you just might not want to do business with, and those are the sort of circumstances that you can and should say, nope, I'm done, I'm out. I'm going to move on to the rental agreement unless you got something else I need to talk about. Any more questions?
What happens if property management companies merge? Do you have to do all new contracts?
Yeah, good question. If property, that's a tough one. This could take a while. I'm not sure we have time. But yeah, if property management companies merge, there's a couple things. If they merge into one brokerage firm, so brokerage firm A merges to brokerage firm B, then yeah, all of the clients in brokerage firm A are going to have to become clients of broker B. So yes, you're going to need all new property management agreements, all new documents all the way around. So if they merge, yes. The other thing is, if the two companies merge and create a third entity, then everybody has to start over. You need new documents for each and every one. So short answer, yes. Unfortunately, yes. Anything else?
Not yet.
All right. The residential lease agreement. I just want to hit on the hot topics here. Hot topics sounds like hot pockets, which my kids used to love. The questions we get: personal property, what's included? Identify it. Just like with the residential resale, identify personal property: washer, dryer, refrigerator, oven, dishwasher, microwave. Write it down. If it's important, ink it, right? Who says this? Bill Gray. If you think it, ink it. So whatever it's going to be, write it down. Occupancy and assignments are another question we get pretty commonly. John and Jane say they're going to occupy, and next thing you know, they're gone, there's somebody else there. Is that a violation? Yes. You can think about it. Specifically, you as a landlord allowed specific people into the property. You didn't grant permission to all their friends and all their family, or the bum they bought on the street. You have the right to control who's going to be in your house. So get the names, get the license plates of their cars, go through the typical due diligence, because what's going to happen if somebody is in there that your landlord did not approve, and that somebody happens to be brewing some meth or burns a place down, guess what? That's something you're going to have responsibility for as the property manager, for allowing unauthorized occupants. The other thing, amazingly, we still get questions on is this security deposit bit. The statutes specifically deal with how much security deposit you can charge. It's no more than 1 1/2 months rent. I can't believe I'm saying that in 2017. That statute's been on the books since I've been a lawyer in 1990, but still people do it. One more piece for comfort animals and for animals helping handicapped persons. You cannot charge an extra deposit for that. Those are not pets under the law. So be careful with that one. Next page on the residential rental agreement, line 91. Again, I said this already, and I want to make sure we're on the same page. If you're charging money for a credit background check, by all means, do it. Don't charge the money and then not follow through, because that's going to be a recipe for disaster. Pets, we talked about a little bit. The controversy we have, I'm now on line 101 of the contract. is service animals versus pets versus animals helping the handicapped. It's a tough issue. It's a difficult one to swallow. Some people have real strong feelings about comfort animals versus service animals and have their opinions that they're what's the right word? Less than stellar, I guess. They're not ideal. The short answer is if they truly are service animals or comfort animals, you as a landlord cannot restrict the occupancy because of that, because almost by definition, a service animal is going to be helping somebody. Well, a service animal for sure is going to be helping somebody with a handicap. A comfort animal, same token. For the most part, comfort animals are going to be deemed to be helping someone with a handicap. If you discriminate based on the animal, you're discriminating based on the person, and you have potential for housing violations. That's a hot topic, and it's a tough one. If you have detailed questions, they're all very fact-specific because you can print these certificates online. You get all sorts of things. So if you have a specific question on that, and I see we have a couple, why don't we deal with those as time permits later, because we could spend the next hour on that question. Unless you tell me I have to take it.
Well, we're just wondering, clarification on if we think they're budging service.
Yeah. Here's a story. You don't want to be in the position of judging whether somebody really has a need for a service animal or not. Because that's a position. A lot of people think that these certificates and these needs for comfort animals are somewhat bogus. That may or may not be true, but the short answer is you typically, at least as a licensee, you're not trained to make that determination. If I'm in your shoes and I have for instance, it's a 300-pound pig in your 1,200 square foot condo on the 3rd floor. I don't think I'd be real happy with that as an owner. That's one of those things where you shift the risk. Get it off of your desk. Get these people, get your landlords out to a landlord-tenant attorney. And if I'm going to give a shameless plug here, Denise Holliday, best in town. She knows her stuff. Dr. Victor's the website. Get it over to her. She'll help you walk through it. They're all very fact-specific. A 6-pound Chihuahua in a 5,000 square foot house, service animal or not, probably a no harm, no foul sort of thing. But if your owner has some issues, fine. But it's the outliers. Again, the pig, the St. Bernard, the python, whatever service animal might be, especially in a small house or small property and multi-family property, apartment, condo, to some degree townhomes. There's where they get really kind of difficult. There's really not one size fits all. So short answer, if you do think somebody's fudging, and if it's serious enough that your landlord really has an issue, don't make it your decision. Say, landlord, you know what, I get it. I understand your concern. That's not my jurisdiction. I'm not licensed to deal with these issues. It's a fair housing violation, maybe, but let's get you to a lawyer and then shift the risk, get it off your desk. One more that's hot. I'm going to hit all the hot topics right now. Marijuana, crime-free provision, lines 160 through 166 of the rental agreement. Can you prohibit marijuana? Can you not? It's legal under Arizona law. Sometimes if you have a card, it's still illegal under federal law. What are you going to do? Again, this is one where all pretty fact-specific. Some people have their opinions about the efficacy of the medical marijuana cards. Some people think if you have a headache and you go to the right doctor in the right part of town, they're going to give you a card regardless, and it's a nod, wink, wink. That may or may not be the case, but still, it's sanctioned by the state. The card comes from the state. It's a legitimate sort of practice under appropriate circumstances. The short answer is this: you can't use the medical marijuana card as a basis to deny occupancy. You can, however, say you're not going to be smoking that stuff in my apartment or in my condo or in my home. You can make those sorts of restrictions. After that, it gets a little bit funky because the argument on the one side is, hey, it's legal under state law. The flip side is it's not legal under federal law, so then this crime-free provision comes in, and we're going to have to argue that. There's really no perfectly good answer. In fact, it's pretty complex and requires you to have all sorts of preemption, is what they call it, when federal and state laws conflict, and the preemption doctrine, effectively federal law governs, so it tells you maybe our state laws wouldn't apply if the feds ever enforced it. Difficult issue. Get to your lawyer with the specifics so they can guide you through it. And again, this is not your question to answer. Get it off of your desk, shift the risk, get it out to a lawyer. Questions on marijuana? Somebody said, how do I get some, right? You know what it says there?
No, a little hazy.
Little hazy, little fuzzy. I'm dazed and confused. One more, and then I'll move on to a different form. Access, we talked about it already. 198 through 204. Tenant may not unreasonably withhold access. So they have an obligation to let you in. If a tenant's playing games with you and not letting you in, that tells you something. They're doing something in there you're really not going to be happy about. So the statutes specifically say the tenant may not unreasonably withhold access as long as the landlord gives 24 hours notice, or sorry, 48 hours notice and does it at a reasonable time. So if you've got a tenant pushing back, say, look, the law and the form, the contract say you may not reasonably withhold access. Any other questions on the residential rental agreement before I move on? And we're short on time already, is that right?
Yeah.
I'm talking too much. I'll move quick. A couple more forms. Notice of abandonment, difficult situation. What do you do when the guy or gal is just gone? 33-1370 governs your rights. The notice of abandonment form is a very good form. Has two sort of pockets. If there's personal property present, you have to do one thing. If there's no personal property present, you can do another. If you haven't ever used it, use the notice of abandonment form. It's super good. And you can't just post it. You have to get it delivered by way of mail as well. Let me find the statute for that. Well, I can't find the statute for that because I got paper spread all over. The short answer is just posting is not enough. There we go. 33-1370A requires notice be sent by certified mail, return receipt requested, addressed to tenant's last known address, and to the tenant's any known alternate addresses. So you cannot just post it, even if you think the return receipt's going to come back to you. Go through the process, mail it. When you get it returned, put that in your file. Look, I did everything I was going to do, everything I was required by statute to do. So notice of abandonment, hot issue. People never been down that path. It's kind of hard to deal with because you got all this stuff in there. You got all this personal property. What am I going to do with it? The form walks you through it pretty simply. Any question popping up, or are we good? No more?
Yeah, I'm sorry.
I thought I saw one coming, so I asked.
What do you do if a tenant has an abandoned property and you don't have a forwarding address?
If you don't have a forwarding address, send it, again, post the property with the notice of abandonment and send the notice, certified mail, to whatever address you have. And typically, I mean, think about the circular nature of this. Typically, it's going to go to the vacant property now. But statute says you got to give it there. So send it to the last known address. Presumably, that's probably the apartment or home at issue. And if they gave you an alternative address, send it there too. Couple more forms and I'll shut up. I've been at this too long. Notice of non-renewal of lease agreement, another good form. Why is it necessary? Because if there is a AAR residential lease agreement used, at the end it goes on and on and on. So you have to terminate it. The lease agreement specifically says, if you use the standard form, that it's going to convert to a month-to-month unless somebody gives notice. So use the notice of non-renewal to terminate the lease. Sometimes people get caught up with that and forget. You can also use the form as the termination of a month-to-month tenancy under 33-1375. Remember, a month-to-month tenancy, the termination has to be 30 days prior to the periodic rental date. So if you're going to, today's March 15th, if you're going to terminate and the rent's paid the first of the month, you have to give notice before April 1st. That notice before April 1st would have the effect of terminating the lease April 30th. If you give notice April 2nd, for instance, you're going to lose 2 months there because April 2nd is not 30 days before May 1st, so you roll over, you got all of May, all of June. Just be careful with terminating month-to-month tenancies because the rules are a little bit hyper-technical. If you've been doing this for a while, you know that, but sometimes people get caught up. Another form, notice of 2-day access. I've beat on this a lot. It's one of the bigger issues. People don't like you as a landlord entering in their property and pilfering through their stuff. So we specifically have a form about the notice you're going to provide. I'm going to come in and look at your property. I'm going to do it for, if you want to tell them I'm marketing, if you want to tell them I want to do a general inspection, you can do that. But short answer is under 33-1343, you have to give them notice. And the form says if you're not there, we'll still do it. We'll still come in. I'm a little bit leery of that, but if you have to, by all means do it. The better practice is to get an acknowledgement from the tenant that you are going to come in and view the property, because that's a bit of a hot button. And again, it leaves you open to getting accused, at least, of stealing the diamond ring or the Mickey Mantle baseball card or whatever small piece of personal property that the folks don't really have, but you give them the margin, if you will, to make stuff up and bring it against you. Another form, notice of tenant. Notice to tenant management termination. We talked about this briefly. If you're going to terminate your property management agreement and you're going to transfer the funds, the security deposit and other deposits to the owner, you have to give the tenant notice. This notice to tenant of management termination is a form to use. It's a good form. It's pretty self-explanatory. And once you do that, you're good to go. The question I get related to that is, well, what about I terminate April 1st, I get a rent check on April 2nd. What do you do? Or you get a rent check March 31st, depending. If the rent check comes in before you terminate, you should collect it, send it on to the owner. If it comes in after, refuse it. I'm no longer the manager. I cannot check that. I cannot accept that rent. Give them the information to get it over to the landlord. Questions on that one or no? One more, disposition of deposits and accounting. This is what you can use. This is the final AR form for the day. This is what you can use when you're giving back the security deposit to the tenant. Remember, you have to do it promptly. 33-1321 requires you to provide an itemized list of what you're withholding and why. So if they trashed the carpet or created a mess that's going to cost you money to clean up, you got to tell them, okay, I had to replace the carpet because your St. Bernard tore it up, and I've got to re-landscape because your horse ate all the grass and whatever else. You got to give them a reason. So tell them what you're doing, why you're doing it, and how much it costs. This 3321 requires that. Most of you know that. I think that's standard practice now. But again, there's always a trap for the unwary out there. All right, I'm ready for questions, but I think we're about time to sign off. What else you got?
Well, just one quick question. Going back to the security deposit, I guess the max amount is 1.5 times the monthly rent. Does that include any non-refundable, or is that any non-refundable charges above and beyond?
That's kind of a slippery slope. Typically non-refundable, the cleaning fee, for instance, is, and Sue Fluke's going to yell at me, non-refundable fees do not come within the security deposit. So a cleaning deposit, pet deposit are not part of the security deposit. Do I have that right? Somebody yell at me if I missed it, but I think that's the right answer. It's lunchtime and I'm tired.
We're not getting any yelling. So.
All right, good. Good. I must have gotten it right. All right, thank you. I'm done for the day, and I hope to hear you or see you again soon.
Well, thanks for coming in, Rick, and thank you for joining us today. Our next webinar will be Mini Market Updates with Tina Tambor on April 19th. As we end today's webinar, I want to remind you of our upcoming Arizona Realtor Convention, March 28th through the 31st in Prescott. If you haven't already registered, we encourage you to do so this week. We have an outstanding program that promises to be compelling, educational, and entertaining. So have a great day.